Juries are widely trusted by the public to deliver fair verdicts in criminal trials. They are 12 members of the public with diverse backgrounds and experiences who, guided by a judge, are called upon to decide guilt or innocence. Independent, collectively free from bias, and fresh to the issues, their task is to hear all the evidence and decide on things like who is truthful or lying or mistaken, whether an act of self-defense was reasonable, or presence or absence of consent in sexual allegations, or whether a defendant acted with a certain state of mind, such as dishonestly or intentionally. This month, the government announced plans to scrap jury trials for offences like assault, sexual assault, theft, drugs, in fact, any offence that's likely to attract a prison sentence of 3 years or less, as well as some fraud cases. Instead, it is proposed that these cases will be dealt with by a judge alone. The reason given for this startling proposal is that it will reduce the backlog of cases waiting to be tried in the Crown Court. The backlog does need to be reduced. It's not right that some defendants, witnesses, or victims have to wait years for cases to be tried. However, there's no evidence that such a fundamental attack on our criminal justice system will have any impact whatsoever on the backlog, nor has the government presented any proof that it will do so. The reasons for the backlog are to do with decades of underfunding, which has left the system on its knees. Removing juries is a knee-jerk reaction, totally unnecessary when there is work that can be done right now to improve the situation. More Crown Court sitting days, getting interpreters to court when they're needed, making sure prisoners are brought to court on time, fixing up the crumbling court infrastructure so that cases are not adjourned and valuable sitting days lost for lack of habitable space because of leaking roofs, lack of water, or other structural problems. More can be done to incentivise early engagement by both prosecutors and defendants to reduce the number of cases for which a trial by jury is needed. This can be done by a diversion or adjusting credit allowed for early guilty pleas. For example, more investment and coordination in out-of-court disposals for minor first-time offences, or increasing credit for guilty pleas at the first hearing in the Crown Court, and ensuring that all evidence is made available early on to the defendant so that they can make their decision about their pleas with the fullest possible information. It may also be possible, with safeguards, to introduce a system whereby a judge will indicate a sentencing range to help provide more certainty for defendants considering their options, including those currently waiting in the backlog. Juries allow society to be involved in trials and decisions about guilt or innocence. David Lammy, our Justice Secretary, previously said, "Criminal trials without juries are a bad idea. You don't fix the backlog with trials that are widely perceived as unfair." In 2017, in his report into prejudice in the criminal justice system, he found that juries act as a filter for prejudice. The consequences of conviction are stark: imprisonment, loss of livelihood, disrupted family lives. If we continue to strive for a more inclusive society, we need trials that are fair and that are perceived to be fair, so by the public and everyone involved in them. This is why I say that removing juries for swathes of cases is a dangerous step, a body blow to our criminal justice system that has been desperately overlooked and underfunded for years. Juries did not cause the backlog. The government needs to reflect on this dangerous proposal and focus on other solutions.